I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series detailing testing the waters under Regulation A+. The disclaimer legend for testing the waters materials utilized following the filing of a Form 1A with the SEC will be substantially the same as the sample legends I described in the last LawCast, but will also contain a link to the filed preliminary Form 1A on the SEC EDGAR database. Test the waters solicitations may be made both orally and in writing. However, all solicitation material must be submitted to the SEC as an exhibit under Part 3 of Form 1A. This is a significant difference from S1 filers who are not required to file Test the Waters communications with the SEC. When a Test the Waters communication is broadcast orally, such as on TV, radio, webcasts, and the like, the transcript must be filed with the SEC. Generally, however, solicitations made orally, in person, and in real time are not required to be filed. Unlike the testing the waters of emerging growth companies that are limited to QIBs and accredited investors, a Regulation A+ company could reach out to retail and non-accredited investors. After the public filing, but before SEC qualification, a company may use its preliminary offering circular to make written offers. Of course, all Test the Water materials are subject to the anti-fraud provisions of the federal securities laws. Like registered offerings, ongoing, regularly released factual business communications that do not include information related to the offering of securities will be allowed and will not be considered solicitation materials. On June 23, 2015, the SEC updated its Division of Corporate Finance, C&DI, to provide guidance related to Regulation A+, including guidance on testing the waters. In particular, the SEC provided the following guidance related to testing the waters using social media. A company can use Twitter and other social media that limit the number of characters in a communication to test the waters as long as the company provides a hyperlink to the required disclaimers. In particular, a company can use a hyperlink to satisfy the disclosure and disclaimer requirements in Rule 255 as long as the electronic communication is distributed through a platform that has technological limitations on the number of characters or amount of text that may be included in the communication, including the entire disclaimer and other required disclosures would exceed the character limit on that particular platform, and the communication has an active hyperlink to the required disclaimers and disclosures, and where possible, prominently conveys through introductory language or otherwise that important or required information is provided through the hyperlink. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.